too many lawyers who draft contracts believing their audience is the lawyer that they're facing for the other party, when really they should be drafting the contract so that the business people can understand the contract.
In terms of general drafting approaches for contracts, one of the things to keep in mind is to not write like a lawyer. Sure, you went to law school and you learned all that lawyer stuff, but the courts don't like it, that a contractual consent to jurisdiction is enforceable. The court just reminded us that a couple of years ago. The question is, does the contract provide for personal jurisdictions?
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers, Ed Smith and Steve Weiss. Edwin E. Smith is a partner in the New York City and Boston offices of Morgan Lewis and Bockius LLP. He concentrates his practice in general commercial and insolvency law. He has been a member of the teaching faculty at the Morin Center of Banking Law Studies at Boston University Law School, where he has taught secured transactions and transnational lending and trade finance. He has also served as a lecturer on secured transactions at Northeastern University School of Law, Harvard Law School, and Suffolk Law School. Steve Weiss is a partner at the Los Angeles office of Prosacker Rose LLP. He practices in all areas of commercial and contract law with an emphasis on the Uniform Commercial Code. Steve has been a member of several drafting committees for revisions to the Uniform Commercial Code, including the 2022 UCC amendments for emerging technologies. He is a member of the Permanent Editorial Board for the Uniform Commercial Code and the Council of the American Law Institute. At the ALI, Steve has been active in reinstatements on consumer contracts, property, conflicts of law, and torts. Steve has been a reporter for many reports on the third-party opinion letters to the Tri-Bar Opinion Letter Committee and the ABA Opinion Letter Committee. Steve is an adjunct professor at UCLA School of Law, where he teaches Uniform Commercial Code Article 9, Secured Transactions. The webinar presentation that you're about to watch will be approximately 1 hour, and time permitting, Steve and Ed will be taking questions from the audience once their presentation is complete. If you have any questions that you'd like them to address at the end of the presentation, please feel free to submit those through the Q&A button at the control panel at the bottom of your screen. Now, without further ado, here are Ed and Steve to discuss effective contract drafting, fundamentals, negotiation, strategies, and key provisions.
Welcome, everybody, to the program today. Ed and I are looking forward to talking about contract law as we work our way through all this. And here's a little cartoon that reminds us that a lot of what Ed and I will be talking about today is clear, objective, linear writing to communicate what the terms of the deal are. Keeping in mind that if there's ever a problem, it's not the lawyers who will be deciding what those words mean. It'll be a jury luckily composed of people who did not go to law school. So Ed and I will work our way through all that and try to help you think about how to draft contracts. Our program will be in two general parts. The first part will cover approaches to drafting and thinking about contracts that apply to all contracts. Contracts could be M&A transactions, they could be leases, they could be sales of goods, licensing, artificial intelligence, something or other. Now, who knows what it's going to be? So we'll talk in general about how to think about drafting contracts in general. Then, because most every contract has boilerplate at the end, that dense stuff, we'll spend a good amount of time thinking about and talking about boilerplate. In particular, we will emphasize that it's important to understand what the law is behind the boilerplate, because you might draft something back in the choice of law clause, for example, that if you draft it one way, it works. If you draft it another way, it doesn't work. And understanding how the courts apply choice of law clauses or a whole range of other clauses we talk about will be important. And then what we will not cover is the substance of, say, an M&A transaction or a secure transaction or something like that, because who knows what kind of contract you'll be drafting. So we'll talk in general about contracts and drafting contracts. A lot of emphasis on clarity and understanding what the words mean, and that the courts don't always give words the meanings you might expect. And then a discussion of the law underlying a lot of boilerplate. Throughout, we'll have quotes from decisions. Some words will be in bold italics, and that's emphasis that we've added, not that the courts have added. So that's going to start it off with thinking about, to whom are we addressing this contract?
Yeah. And I think, Steve, there are too many lawyers who draft contracts believing their audience is the lawyer that they're facing for the other party, when really they should be drafting the contract so that the business people can understand the contract. But even more importantly, if the matter is litigated, that a judge who may not be familiar with the parties or the technical language can understand the contract. So think about who your audience is. It's generally going to be the clients that you're representing, but also a court, if a court has to interpret the contract. And that sort of leads us into a lot of different ways of approaching contracts that Steve's going to talk about.
So we want to be sure that, as I mentioned before, that everybody understands the terms of the agreement and whether what you write can actually work or not work. And one general theme we'll have today is that, sure, courts in the United States are generally contractual or contractarian, as some of the courts like to say, and they'll enforce the deal. Whatever the deal says, the courts will work their way through all that, and went a little too far. But it's important to understand that the courts won't let you go all the way through. And as one thing that Ed points out is that the parties need to understand the deal. And one thing you want to think about is, does the client really want everything you might, as a knee-jerk matter, throw into the deal?
So the question really is, think about what your client's objective is. The example here is someone put in an arbitration clause thinking, wouldn't it be nice if any disputes under this agreement were arbitrated? It turned out the client was then flooded with arbitration claims, and in retrospect would have liked to have had, let's say, a class action to deal with all of them. So you've got to think about, even in the boilerplate provisions, whether those provisions are provisions the client really wants.
So as I was starting to mention a few moments ago, courts in the United States, common law contracts, generally enforce contracts, and you'll see the word sophisticated highlighted here. You'll see over and over again in the case, the courts say sophisticated people enter into a contract, they made their deal. Commercially sophisticated parties sign what they sign, and we, the courts, not our job to step in and fix the deal. Here's sort of a cute quote from a recent decision, noting that one of the parties implores this case is simple, and the court said, sure is simple. You made a really bad deal, but you agreed to it, and we, the court, are not going to fix it for you. So the point is to be sure the document reflects what the deal is supposed to be as you work your way through all of that. And the courts, again, though, will have some outer limits. And a lot of what Ed and I will be talking about is, what are those outer limits for courts? First, we note that even in California, where people sometimes think the courts don't enforce contracts, the courts in the California Supreme Court recently reminded us that it will enforce a contract as written and agreed upon by the parties, if you can figure out what they agreed to, subject to, though, a significant public policy concern. And Ed and I will talk about what some of those significant public policy concerns are and why you don't want to go too far. We'll give you lots of examples. Even Delaware, which is famous for applying the contracts as they are written, says, but even we have some limits, and as the Delaware Supreme Court recently noted, common law abhors a forfeiture, and there are other policy limitations on what a court is going to enforce. So we'll talk about what you can write, what you can agree to, but you don't want to go too far. And as we'll show in a couple of minutes, you might think, well, I can just overdo it and the court will cut it back to what's enforceable. Not always the case, so stay tuned for that. So in terms of general drafting approaches for contracts, one of the things to keep in mind is to not write like a lawyer. Sure, you went to law school and you learned all that lawyer stuff, but the courts don't like it. Here's a case in California 9 years ago. And when the court starts talking about jaw-breaking 497 word sentence, you can already tell who's going to lose this case. So you really want to write, again, as Ed said, think of the audience, the business people, or perhaps a jury. You don't want to have what the court here disparagingly refers to as 19th century legal writing. Here a court rails against lawyers who use two words where the one word will do. Again, going back to Old English, the court had fun. But again, it's not hard to figure out who's going to win when the court starts complaining about how the contract is drafted. Here a court the California Supreme Court refers to the agreement as a paragon of prolixity, single dense paragraph of 51 lines. I was an expert witness 25 years ago in a case, and the whole case, $750 million, turned on the interpretation of a single sentence. The problem was that single sentence covered an entire page, and we were arguing about what that single sentence meant. And it was the hope of getting a jury to understand that, or a court to understand that, is really something of a long shot. Here again, another disparaging reference to dense agreements interspersed with confusing signature block. You want to make it as clear as possible in order to have some hope of getting the contract enforced as you go along. So as I noted before, courts in the U.S. generally say will enforce the contract as written, subject to some sort of public policy provision. And as I also mentioned, you don't want to go too far. And don't assume, and here's 4 or 5 cases that make this point, that if you go too far, a court will get its delete button out or delete key and cut it back to what's enforced. Because sometimes, as these cases point out, and here's just a very recent case in California from a few years ago and another one from last year. And what the courts will sometimes do is say, if you go too far, we're not just going to cut out the bad language. We're going to cut out more to create an incentive for you to follow the rules, because it may be that sophisticated lawyers representing sophisticated clients will know about all of these important rules that Ed and I are going to talk about as we work our way through this. But less sophisticated lawyers or less sophisticated clients may not be familiar with those rules and may not raise those problems. But what the court says here, California Supreme Court last year, says we're going to take a look and we're not going to necessarily sever the bad part of the paragraph or the contract. We might throw out more than you think. So don't think that the court's going to do your work for you. Here's again that same case. And the court said the more unconscionability, the greater the probability is the court would toss out a particular agreement. So the important thing here is pay attention as Ed and I go through this in the balance of this program to what's enforceable, what's not, and sort of caution yourself. And don't assume, again, the court's going to save it for you if you go too far, because the court might decide they need to create a disincentive for people going too far and knock out more of the contract than you think. But before we get to the question of enforceability of a contract, we have the question of, is there a contract? And lots of deals begin with a term sheet or letter of intent or something like that. And if that particular document itself is not a binding contract, then there's nothing to breach. There's nothing to enforce. It doesn't matter. Sometimes those contracts are partially binding and partially not binding. Non-disclosure and confidentiality provisions may be continuously binding. So if you want something to be not binding, say so. Courts will uphold that. Here's a recent case here in the Southern District of New York. Term sheet said it was not binding, and by golly, it was not binding. The other thing to think about is more and more contracts are being entered into online. Does the clicking, I agree, does the continuation of the browse wrap create a contract? There are many, many cases in the last 20 years addressing this, how the terms and conditions differ from the core provisions of the contract. There's lots to pay attention to here. And the American Law Institute has recently issued a restatement on consumer contracts, how to form a contract, form or adopt terms and conditions in addition to the core provisions of the contract. While the restatement addresses consumer contracts, the test used in the restatement is the test the courts use for all online contracts, taking into account the phrase totality of the circumstances. And in a commercial transaction, the courts are probably more likely to find adoption of terms and conditions and in a consumer contract. But the test itself, reasonable notice, reasonable opportunity to review, those kinds of applied across the board. So, assuming you've got a contract, assuming you don't go too far, the next question is, Ed and I will get into drafting and ambiguity. Ambiguity, yeah.
So we start with the idea of write clearly. Now, this is like my mother telling me when I climbed a tree, don't fall. So we're going to try to help you write clearly in the rest of this presentation. And the one thing you should always try to do is to avoid ambiguous terms. I'm often reminded of Baird Jackson that talked about this 19th century case involving a tannery that would prepare and sell hides over the course of time. And in November, the tannery granted to its lender a security interest in its hides. And then later in March, there was a big dispute. The dispute was whether the security interest only covered the hides of November, or also covered the hides of March. So be aware of these ambiguous terms. Also, and let's go to slide 32, remember that when you're dealing with a particular industry, it's not unusual at all for a court to construe contractual terms that follow industry custom and usage. So if you're using Incoterms for shipping, for example, a court will look to see how those terms are interpreted. So you've got to bear those in mind too when you're writing clearly. And then Steve has some other hints for us.
Okay, so again, these are general points that Ed and I are now making that apply to any provision of the contract, whether it's the whereas clauses in the front or the final boilerplate integration clause at the back end of the contract. And we'll go over this in a little bit more detail, use the active voice, we'll explain why, punctuation, the structure of sentences, all these things that at least I learned in my 7th grade English class, my terrific English teacher, Mrs. Grayhack, many, many years ago. Keep modifiers of phrases as close as you can. Don't turn verbs into nouns and nouns into verbs as you go through this, because you're just sort of asking for ambiguity. Always better, if possible, to use simpler words, as one court said a few minutes ago. I referred to rather a few minutes ago. Don't use 2 words if 1 word will do. Don't use legalese. Avoid jargon, although trade usage, as Ed pointed out, can be very useful. Don't use fancy lawyer-like words. Again, it's the business people that should understand the deal, or jury, not the lawyers. The lawyers are not going to be the people deciding what those words meant or what the overall deal was for the transaction. Passive voice. I mentioned using active voice. Passive voice, as the United States Supreme Court reminded us just 2 years ago, pulls the actor off the stage. If I say the agreement will be delivered, doesn't say who's going to deliver it. If I say Ed will deliver the agreement in the active voice, then we know whose responsibility it is. So very simple drafting of sentences can matter a lot. Again, here's the Delaware Chancery Court pointing out that when something is written in the passive voice, you don't know who's supposed to do it. You've got an ambiguity that Ed told us just now to avoid, and you don't know where you're going to get. Here again is that case I mentioned a little earlier from 20 years ago. Lawyerisms, multiple words, try not to do it. Clarity. Clarity is the opposite of ambiguity that Ed was talking about. And in that clarity, sometimes people think that capitalizing a word or a sentence makes it clear. Not the case. And as Ed will talk about later, for conspicuousness, all caps does not make something conspicuous. So don't lean back and think that just using all caps will solve your problem as you work your way through this. Grammar, good old-fashioned grammar, periods, commas, semicolons, colons. The courts don't like to use that, but if they've run out of other methods to interpret the words of the contract, they're not adverse to turning to grammar and figuring out, well, we tried the usual rules of interpretation. They didn't lead us to a conclusion, so we'll fall back on the use of grammar as we work our way through this. So again, pay attention. Get your Strunken Light or whatever grammar text you like out, and be sure you follow the rules of grammar as you work your way through that. The words which and that often get a little bit messed up. The word which is a non-restrictive clause. The rake, which is in the garage, is broken. Doesn't tell you which. It doesn't tell you that it's a particular rake, rather, as opposed to, and this example comes from Strunken Light's English usage, or the word that, the rake that is in the garage, tells you that I've got more than one rake, but I'm talking about the one in the garage. And this could refer to collateral or something like that. So again, watch out. The simple rules of grammar can when they're applied, can make a difference. Parallel structure. If you've got two clauses and they're intended to do the same thing, the courts might look at whether the structure of the two sentences, subject, object, verb, how they're arranged, can affect how the court will interpret it. And what courts will sometimes say, as they did in this case, if there isn't parallel structure, then there wasn't an intent to get to the same place as one works one's way through that contract. The visual preparation of the document, the layout of the document can make a difference. The font. Make sure the font is readily readable, particularly if it's an online contract. And the courts here, just again, last year, were complaining about the font used in a contract. So use a font that works for paper contracts, a font that works for online contracts. There's lots of learning out there. The courts have rules in litigation for what font you ought to be using or not using in particular circumstances. Again, in laying out the document, keep in mind that you want it to be easy to read. As I referred to a few minutes ago about this expert witness matter I had 25 or so years ago, the paragraph was left margin to right margin, one sentence, an entire page. Very hard to read, very hard to parse, easy to get confused. Much better to use bite-sized chunks, bullet points, not have a right justification, captions and headings. We'll talk about some of these things a little more. Using tables to provide information, hanging indents with bullets, watching about how you could use a modifier for a list. We'll come back to some of these as we work our way through all of this. But again, it's not just words you put on paper, avoid those lawyerisms and all that, but also the visual presentation. Imagine in litigation, one of the lawyers putting your page up on a giant screen in the courtroom and asking the jury to try to interpret it. You want it to make that as easy as possible. So, Ed, I mentioned conspicuousness, which is sometimes important. What do the courts tell us about that?
Well, the one thing they do tell us is just making capital letters is not in and of itself conspicuous. That you've got to look at the entire document. And probably the easiest way to get into this is to look to the definition under the Uniform Commercial Code of what is conspicuous. Now, there are a number of provisions in the Uniform Commercial Code that require clauses to be conspicuous, and this was designed to provide some guidance on that issue. But you'll see it means that the term is so written, displayed, or presented that based on the totality of the circumstances, a reasonable person ought to have noticed it. And if you go to the comments to that section, which are based really on the AOI's Restatement of Consumer Contracting, you'll see a lot of explanations that are very helpful. Here, there is a distinction between a standard form contract where you have to think of who is the most likely party to the agreement. Or if you're dealing not with the standard form, what a reasonable person would notice in the contract. And because contracts can be written, they can be electronic, they can be used in different fonts, you've got to be able to think about the totality of the circumstances for that term to be conspicuous. There are also other things that you can do. You can use captions. Now, Steve and I learned very early in the revision process to the UCC how useful captions could be in giving signposts to people as to what the substance of a particular paragraph contains. But the one thing you should be very conscious of if you're going to use captions is to make sure they correctly describe what is going in that paragraph. You shouldn't have a caption that sends people in one direction when the paragraph itself has its substance going in the other direction. And then also try to avoid redundancy. I mean, we all tend to do this from time to time. I assign, pledge, hypothecate, grant a security interest, mortgage, going on and on and on, when one or two words, assign or grant a security interest, would probably do the job. And just adding all of these other terms just confuses things and make people think that there are more meanings in those terms than there actually are. And then when we get to definitions, avoid defining a term in itself, saying X equals X. And then another key thing is not to have substantive operative provisions in the definition itself. The substantive operative provision should be in the body of the contract. And then if you're going to use defined terms, make sure you use them consistently. There are a couple of cases here on the slides where the drafter used initial caps to define some terms and then used lowercase caps elsewhere in the agreement. And the court was wondering whether the lowercase terms were the ones that were the defined terms. And it really created more ambiguity that was needed. If you don't use, if you use a lowercase term, a court is more likely to just provide the natural meaning for the term rather than the defined term. But if the defined term is intended, then you should have it capitalized. And then also be aware of definitions that are defined in various statutes, especially statutes that have a substantive link to the topic of the contract. Here you have a case where the word assume was used, and instead of what may have been intended, assume meaning as, let's say that this is a fact when it's really not, or we're going to proceed on a certain assumption. The court said, well, assume means you're going to assume all the obligations of the party to the contract, because that's where the bankruptcy code uses that term. So be aware that when you're using terms in a contract in the light of a specific substantive context, you may be incorporating interpretations and definitions from other statutes. So, Steve, what about conditions and modifiers?
So one often sees a list, A, B, C, and D. The following will be provided, or something like that. And then at the very end, there's a provided, however, or to the extent that, or some limiting phrase. And the courts often find themselves having to decide whether the limiting phrase limits only the last item in the contract, or limits, in the list, or limits every item in the list. So you want to think about that. And sometimes if you want to be sure if the intent is to modify, limit, address every item in the list, you say in each case, or put the modifier at the beginning of the list, all of the following to the extent that A, B, C, D, and then list your items or something like that. But there are endless cases about whether the modifiers at the end apply to the entire list or not. People like lists. They think specificity is good. And then they'll list 1, 2, 3, and 4. And then 5 will be and other similar stuff. So the question is, what does the other similar stuff pick up or not pick up in that circumstance? And the courts often apply a test to say, well, the catch-all at the end has to be sort of kind of similar to the other items in the list that the court can derive a principle or something like that. So if that's where you are and you want to be sure you've picked up everything you intend to pick up, think about whether you need to be more specific in the list once you decided to use a list. A presentation form that I think is very helpful is using tables and charts to provide information in an agreement. One of the things to avoid is to have too many lines in the table. All those vertical and horizontal lines creating little boxes makes it hard to read. What I try to do is, and there's a famous professor, a guy named Edward Tufte, who says use the minimal number of lines. Often, if you look at it, the horizontal lines to separate each row are fine. You don't need the vertical lines because the captions at the top tell you what's in each row. Be sure in your word processor that you trigger the settings so the captions repeat themselves on each page. Put comparative information above and below each other as you work your way through all that. Again, these are all techniques to think about. I made some jokes before about grammar and commas and which and that, but here's a whole long discussion of commas. A whole comma can make the difference in what the court decides something is going to mean. So step back as you draft it. When you get all drafting, if you've got time before you deliver something to the other side, work your way through it. Look at the grammar, look at the words, look at the lists, and think about some of these techniques of presentation. Are the sentences too long? Are they understandable? So what Ed and I are going to move to now are words you thought you knew the meaning of, but the courts sometimes decide that they're going to interpret it differently than what you might have thought the common dictionary meaning was. And Ed will start with, one of the shortest words possible.
Okay, well, it's true that one of the shortest words possible is the word and in this case, there was an actual statute that talked about a notice. And so the court said, a notice sounds to me like a single piece of paper, a single document, not a whole series of different documents that when you combine them together is a notice. So that's one example of a court applying a common meaning to the word that was contrary to what at least one of the parties thought the word meant. So, Steve, how about fraud and willful misconduct?
One often sees in releases or indemnities or limitations of liability that they apply except when there's fraud or something like that. Well, what does fraud mean? Does it have a definition in the contract? Does one resort to the meaning of the word fraud in the common law of torts? Does one even know what the meaning of the word fraud is in common law torts? Again, if you've got one of those kinds of clauses, stop and think, do I want to provide some specific definition to this in order to give more clarity, because it might really matter. And the fact we've got these cases talking about it shows that it does matter. The next half dozen or so cases are sort of amazing. You'll have a contract that says that the choice of law for claims arising from and or relating to the contract will be the law of Delaware or New York or whatever. The courts spend a lot of time sometimes what differences between arising out of and relating to. And when they see arising, they say, well, that has to be closer to the contract, while relating to or in the penumbra of the contract. So not going to talk about these cases very specifically, but these are matters that the courts are very serious about. And if you intend the broadest possible application of a clause, probably you want to say arising out of or relating to. If you want a narrower one, you would want to say arising out of as you work your way through it. Here's a U.S. Supreme Court case 4 years ago where the whole case turned on whether the word relating required a causal connection between the and the contracts itself. So who knows? Excuse me. Again, the same thing in interpreting statutes can apply as one works one's way through this. So presented a lot of cases just to show this is not an idle issue. This can really matter. Now, yeah, do you like to say shall or will, or what do you say in a contract is supposed to happen?
I could say shall or will, but they both imply something that's going to go on in the future, not something that's done when you sign the contract. The example I like to use is the Dolly Madison case. I agreed to grant you a security interest. Well, okay, I didn't do it in the security agreement. I only agreed to do it in the future. And shall is very much along those lines. Then we get to the word so, and to make sure where you use the word so that you're referring to the right thing that is so. And here a court had to struggle with what that really meant, where that term was used. And then we can go to the word you. And generally, if you're using the term you, you're referring to the other party to the contract. If there are multiple parties to the contract, though, you got to specify who you mean by you. And then we have notwithstanding. I had a partner who loved to draft contracts with a general rule and saying, then the next clause would be notwithstanding the foregoing, and then the next clause would be anything to the contrary in this agreement, to the contrary, and then another was notwithstanding the foregoing, and you didn't know whether you were coming or going on the clause. What I usually like to do is to provide the general rule and then to say subject to A, B, and C, or subject to with A, subject to B, so that people know which clause trumps which other clause. But it can be very, very confusing if you have the whole string. Another is the distinction between and or. And Steve, tell us about that.
Yeah, so we all grew up learning that and is conjunctive and or is disjunctive, except when the court tells you it's not. And again, you might say, well, that's crazy, Steve. But it's not. And the courts you see here in this case and the next case, we just give them as examples, tells us that sometimes or is conjunctive and is disjunctive, or it can create an ambiguity. There's that nasty word Ed told us to avoid. So as you draft again, whether you use you or a or notwithstanding or and or, think about, is it clear what the intended meaning is? Because you're not always going to get what you think you're going to get. So there can't possibly be any ambiguity in immediately, can there?
Well, immediately generally means right away. Right away, without delay. But sometimes you see immediately contrasted with the word promptly. And I think there's a little more wiggle room with the term promptly. Maybe you can say, well, it doesn't mean right away, but it means pretty soon afterwards. So think about what you really intend. If you really intend right away without delay, then put in the word immediately. And then, Steve, what about singular and plural?
Yeah, so again, you would have thought, how could that possibly matter? But in a particular case here, the question was whether the plural word buyers was intended to mean plural buyers. And the court noted, it went back through the 24 drafts of the contract, and it was plural in the first 22 or 21 rather. Then it came out in a few drafts, and then it came back. So the court decided it was intentional that it was plural, and the plurality, the plural nature of the word had an effect on the interpretation of the contract. So again, you got to pay attention to every comma, every word, every conjunction as you work your way through that. And we've got some more maybe synonyms here: reaffirm, ratify.
Yeah, well, reaffirm means you're just taking something that worked before and you're telling everyone that it's going to work, it's going to continue to work. But then we have this word ratify, and ratify really goes a little farther. It can cure problems with the original provision. So let's suppose in this example you had a guarantee that was voidable, but then it was ratified, which means that the voidability problem went away. And so think about what you really mean. Do you mean that you're just trying to confirm what was already done right before, or do you want to make sure that if there are any problems before, that they're being fixed by the ratification? One of the most litigated terms that we see, especially in M&A transactions, is the word material. And here the court refers to that term as a slippery term in contract law. And what do we mean by material? I think we mean that, as the court says here, that the provision goes to the heart of the contract. Now, trying to figure that out in a particular context may be difficult. What I sometimes do when people say, well, it's got to be a material breach, I sometimes say, well, it has to be a breach in a material respect. To make clear that you still have a breach, you just have to look at how serious the breach is. And then we have this term affiliate. And usually affiliates can be understood to be parents, subsidiaries, sister companies, all under some sort of common control, but sometimes it's not all that clear what an affiliate is. I litigated a case in one of the major bankruptcies over whether a affiliate included a trustee of an investment fund, just because the trustee happened to be affiliated with another company in the group. So be aware that you might want to be careful as to how you define affiliate. And then there is this term we often see in accounting language, consistently applied. And in this case, someone heroically argued, well, it wasn't correct, but at least I consistently applied the incorrect term. And the court said, no, that's really not what that meant. It meant consistently applied in accordance with the proper accounting rules. So, Steve, we often hear terms like best efforts, reasonable efforts, commercially reasonable efforts. What does all that mean?
Yeah, so the courts sometimes try to come up with some nuanced, neat differences in these meanings. And then even when it says best efforts, does that mean you've got to spend all the money on earth to try to get there? Is there some outer limit on best efforts, how much you have to spend, material amounts? That word Ed just talked about a little bit. There's no clear answer to this. Some folks think there's really no difference. Commercially reasonable efforts adopted from the UCC are, as in my favorite body of law, puts it into the commercial context. Just be careful in using these words, and if it is best efforts, you maybe want to build in some limitation on how much time, how far do you have to try, how much money you have to spend as you work your way through all that. Similarly, ordinary course of business. We had a question here that is the operational history of is it the person? Is it the industry itself? How do you figure that out? Whose ordinary course of business? In the UCC, we've got all sorts of provisions. Seller's ordinary course of business, buyer's ordinary course of business. It can all matter. Come back to the active voice and figure out who's supposed to do what as you work your way through all that. The next set of slides, we won't go through them individually, have to do with choice of law, choice of forum, personal jurisdiction clauses. And the key here is to understand the general rules as you draft these clauses. And I won't stop in any particular case. You want to start with, and many of these cases do, Section 187 of the Second Restatement of Conflict of Laws. Section 187 says if you choose by contract the law of a particular jurisdiction, and if there's any kind of reasonable tie or basis to do that, the courts are going to enforce that unless the application of that jurisdiction's law will result in the violation of a fundamental policy of the jurisdiction whose law would apply in the absence of the choice of law clause. So you want to think about as you do these things, whether how far you want to go, because if you choose a jurisdiction whose law is not going to be applied because there's no basis to apply it, for example, then you're not going to, there's no fallback. Rather, you go to the general rules of choice of law and you look at contacts with different jurisdictions and things like that. And then you're at risk as to what the court's going to do. As to state law claims, federal courts will apply the law applicable by a court physically sitting in that state. So you do want to pay attention to that. If the question is the formation of the contract, there is no contract to enforce the choice of law clause. So you end up with general rules of contract law to figure out what's going to apply. Some states, California, Delaware, New York, Illinois, have rules that govern inbound choice of law clauses, and typically those don't have a public policy exception, except for California, which does have a public policy exception. So as you work your way through, do want to think about that. It is possible, and it's okay to have different laws applied to different elements or provisions of the contract. There's a nice French word called dépassage mentioned there in the fourth line that tells us about that. How about tort claims? Does the choice of law clause apply to tort claims? Well, it can, if the proper interpretation of the choice of law clause is that applies to tort claims. Claims arising out of, relating to the contract. Does that pick up a tort claim, a fraud claim arising out of or related to the contract? Maybe, maybe not. The court will interpret the contract based on all these interpretive rules that Ed and I have been talking about. Same thing on statute of limitations. Does the forum's statute of limitations apply, or does the statute of limitations of the law chosen by the contract? Some states take the position that the statute of limitations is part of contract law, so the law applies to the contractual disputes applies. Others say, no, it's procedural, and the law applicable to the forum applies. The general trend is to apply the contract law choice of law clause to the statute of limitations, but, who knows what's going to apply in that circumstance. So all of this is, again, stop and think about it. And the courts generally will say we're going to hold people to their bargain. Similarly, for choice of forum clauses, the courts will generally enforce all of those, but there are a couple things to be careful about. Here are those short word things again. In the Siminoff case, the contract said that the forum would be courts in a particular county. Well, that particular county had state and federal courts in that county, so the party enforcing the choice of forum clause could go to a state or federal court, as opposed to a clause that said the courts of Virginia. The courts of Virginia were only state courts, did not pick up federal courts there. Or another one, somebody needed to buy an atlas because the litigation will be in the federal courts of Lynn County, Oregon. The problem was there were no federal courts in Lynn County, Oregon. The party seeking to enforce it said, well, there are federal courts in the next county over called Lane County, and they both start with an L. So we ought to enforce it. And the court said, no, you wrote it. You've got it wrong. You better check next time before you do all that. Even if you do it right, so to speak, for federal courts and the forum selection and whatnot, if the application of the forum selection clause is going to result in a substantial loss of rights under the law of the forum, the first forum, the courts will often be reluctant. California has a lot of cases in this area. There is a case pending right now in front of the California Supreme Court. There is going to address this exact issue. So we may have some new law to interpret as we work our way through all that. Personal jurisdiction. There have been a lot of Supreme Court cases on whether there's personal jurisdiction, breach of contract, tort claims. The one thing we do know is that a contractual consent to jurisdiction is enforceable. The court just reminded us that of a couple of years ago in the Mallory decision. So no doubt about that. But the question is, does the contract provide for personal jurisdiction? So if you care about that, do be sure to say the parties all each consent to the personal jurisdiction of courts in a particular case. The parties do not have the power to confer subject matter jurisdiction on a court that does not otherwise have subject matter jurisdiction. So you can write it, but it's a waste of printer toner to do that, or electrons in that PDF on the screen, because the courts control, or the statutes control, their own subject matter jurisdiction. Moving on to contractual apportionment of liability, the restatements say a lot about that. The general rule is, we'll enforce a cap on liability or a limitation on liability, but like several of the cases I mentioned very early on, there are limits, whether it's the forfeiture limit in Delaware or strong public policy limits in California. Here again, we have a Delaware Chancery Court where a lot of business litigation occurs, and it's okay to use limitations of liabilities, the court says, in measured doses. So don't go too far, and keep in mind my earlier comments that courts won't necessarily sever the unenforceable clause from the enforceable clause, and they may toss out the entire provision. Courts generally will not enforce a limitation of liability clause that applies to reckless conduct or fraudulent conduct. Some states that won't enforce it if it applies to gross negligence as opposed to ordinary negligence. So think about whether you're chosen a law that will enforce what you've written. Because again, if the court throws out the entire clause, not only do you use the reckless conduct liability limitation, but you might lose it for plain negligence conduct liability. So the don't go too far provision is something you do want to keep in mind as you work your way through all this. And Ed, how do courts tend to interpret these clauses?
Well, this is once again the importance of careful drafting. Let's take an indemnity clause. It looks like if there is an ambiguous term, that term may be interpreted against the indemnity. Then there's always the question with these indemnity clauses as to whether only third-party claims are included in the indemnity if the indemnity gets sued by a third party, or whether the claims also include the parties to the contracts. And then there are the carve-outs from these indemnity claims. So what happens if the indemnity was negligent or grossly negligent? To what extent are those carved out from the indemnity? And what do we mean by gross negligence as opposed to negligence? Generally when we're talking about gross negligence, we're talking about some sort of near intentional wrongdoing by the party. It's not unusual for one of the major negotiations in indemnity to be the distinction between the negligence carve-out and the gross negligence carve-out. And then we also just have general questions about the scope of the indemnity. Does this apply to indemnity claims that arose before the contract is signed, or indemnity claims that arise after the contract is signed? And then are consequential damages generally excluded, either from the indemnity or from a breach of contract action itself? As a general matter, courts have upheld an exclusion of consequential damages. So you cut off consequential damages, but Steve, can you limit damages otherwise?
Well, the courts tend to say that it's okay to limit damages as opposed to exclude liability for these bad gross negligence or worse kinds of conduct. But the limitation itself can't be so small a number that it functions as a complete exculpation clause for gross negligence or something like that. And we do have some recent cases in California that won't even allow limitations for damages at all for violations of law. So there are lots of nuanced provisions in here. And if you're really negotiating one of these, take a look at all these cases Ed and I cite as we work our way through that. And sometimes people try to address this by saying the other party won't rely on extra contractual statements or certain types of things that are provided. Does that work?
Well, generally you can have an integration clause saying this is the entire deal, but then within the contract itself, sometimes you see things saying the parties will rely only on the representations and warranties are made in the contract. And courts have generally said you've got to be very specific as to what those clauses rely on. And then what about modification clauses? These are clauses where there are provisions that provide for how an agreement can be amended or otherwise modified. And here where a court said, well, only or one party can modify the contract at its own whim, that creates an illusory contract, which makes the contract unenforceable. Typically, what you have where you're going to go this direction is give notice to the other party and an opportunity for the other party to walk away from the contract if it doesn't like the term. But it can't just be totally in the discretion of one party. And then, Steve, what about liquidated damages?
Well, so we all learned about liquidated damages in our first year contracts class, and the liquidated damages number has to bear some kind of relationship to the likely amounts of damages, even if they're hard to calculate and all that. But the question is, which contract do you look at to determine that? And here, in this case, there was a lease. The lease was renegotiated. A new agreement was entered into. The new agreement was breached. And the liquidated damages clause was arguably reasonable or okay or enforceable if you looked at the potential damages under the original contract. But here it was for breach of the new contract, the surrender agreement under the lease. And the court said it went too far for that agreement. So the court was not going to enforce it. So we're going to think about how that all works. We've got fiduciary duties that pop up, and we're not here talking mostly about family trusts and things like that, but rather you may have an agent for a loan where there are multiple lenders, and it's okay for that kind of a commercial agreement, which creates some subset of fiduciary duties to provide limits on the scope of the fiduciary duties and allow some conflicts of interest and all that. That's important if you look at the restatement of agency, that not all of these relationships are agency relationships that create a fiduciary duty. It's only an agency relationship of the supposed principle that creates a fiduciary relationship. And if a borrower gives the secured party certain rights, say to vote pledged stock, that doesn't create an agency relationship because the borrower doesn't control the secured party. So there's no fiduciary duty that arises in that particular context. But you do want to be as specific as possible as you work your way through all this. And in a lot of transactions, there's assignments of various kinds of rights, and sometimes contracts can't be assigned. Sometimes they sort of kind of can. How does that work?
Well, first of all, I think it has to be understood what is meant by an assignment here, because you can often assign rights and delegate duties without violating a particular contract. If you want to prohibit the delegation of duties, you should probably make that specific. There's also a question of how far the anti-assignment term goes. For example, if Company A agrees that it won't assign any of its rights or obligations under the contract, but Company A is sold to Company B, who takes the equity in Company A, is that an assignment of the contract? If you want to include that sort of change in control, you ought to define that. And then the question is, what sort of remedy is there for a breach of a contract? Usually, if it's stated in the contract that the breach of the anti-assignment clause, the assignment in breach of the clause is void, then it has no effect at all. If it doesn't say it's void, it just creates another breach of contract claim. And then finally, you have the Uniform Commercial Code, which in some cases overrides anti-assignment clauses, especially when you're dealing with rights to payment. So you should be aware of those as well. So, Steve, back over to you for anything else. Third-party beneficiaries.
In just another minute or so here, and we'll wind it up. Third-party beneficiaries usually have to be fairly expressly created, but that's not always the case as you work your way through that. Sometimes parties try to limit or expand the statute of limitations. Courts generally allow a shortening, but not too short, of the statute of limitations. The party who's not in breach has to have a reasonable time to discover the claim or something like that. Some states limit the ability to extend the statute of limitations. Delaware is pretty open-ended on that. New York says that a pre-breach provision doesn't apply. California has a very specific provision. Again, go back to my earlier comment about the choice of law and how that applies to all of this, and whether a particular state's statute of limitations applies or not. Waivers of warranty notice and whatnot also can matter. Jury trial waivers, California does not allow a pretrial jury trial waiver. New York does. Again, look at the state, look at the forum, look where inter litigation might occur. And I think we'll skip over commercial impracticability and the like. And the last thing to cover is, surprisingly, often a contract will incorporate by reference another provision. And the courts are a little bit hostile to this for some reason. And they make a big point of saying, if you're going to incorporate something by reference, you better make sure it's clear, make sure it's not just a general reference, but it's an incorporation, and that the other document is, as the court says here, easily available to the other party so they can see what they've agreed to in these circumstances. So, Nina, we're going to turn it back over to you for any closing comments and CLE information.
Wonderful. Thank you both. Now, do you both have time to answer a few questions? We do have some in the Q&A if you all have time for that.
I have a few minutes. Go ahead.
Okay, wonderful. So our first question is from a participant. They ask, do juries decide contracts, cases, or judges, or does it depend on the type of contract?
I think it depends on the type of issue involved in the contract. So it's, say, an interpretive issue. Judges may decide that, but ultimately it may be a jury that says, well, the judge instructed us to apply usage of the trade, let's say, and now we, the jury, are going to find what was the usage of the trade based on the evidence presented, something like that. I mean, Ed, what do you think?
Yeah, a court would generally interpret the contract as a matter of law rather than giving it to the jury. But if the contract is ambiguous and parole evidence is admitted to explain what the parties intended, that would be more of a factual finding, which could go to a jury.
Awesome. Thank you both. This participant, Rachel, asks, can you explain why some information is contained in whereas clauses and other information is not? What is the purpose of whereas clauses, and is there a better way to lay out what the contract is about?
So Ed's smiling. He knows that I was involved recently in a very large decision, a matter where the effect of the whereas clauses was critical. The whereas clauses referred to what might or might not be collateral, and then the agreement itself also had references to collateral, and there was a lot of dispute over whether the whereas clauses were operative or just sort of descriptive of the background of the deal. The court held in this particular case, based on the particular wording of the particular whereas clause, that it was an operative clause and that it was operative to describe the collateral. Often, whereas clauses are not intended to be operative, and they're just sort of laying background, but there was a vast amount of time and argument spent on this particular issue. So if you want it to be operative, better to put it in the operative provisions of the contract. And if you don't, you want to make that clear also. And any comments on that?
And Steve, exactly right. The whereas clauses are just intended to tell a story as to why the parties are entering into this contract. Nothing more than nothing less, just providing certain guidance. And I've often thought that using terms like whereas was going back to the Old English. What I've sometimes done in contracts is just start off saying background, as you pointed out, and then have a paragraph explaining why the parties are entering into a contract, and then you have the substantive provisions.
Awesome. Thank you both. Our next question, we have time for two more, so then two, and I'll let you go. But this next question is from Kayan. They ask, can a dissolved entity be released of liability from a settlement? Can an attorney no longer working on the law firm and without representation be released from the settlement? So would either of those apply?
I think that's a substantive question that goes beyond drafting.
Awesome. Thank you both. The next question is from Stephen. They ask, is AI something that you would say is helpful, marginally useful, or not so much when it comes to contract drafting? What do you all think about that?
Well, I think you do. Go ahead, Ed.
No, I was going to ask you, Steve, have you used AI for contract drafting yet?
No, I'm not at all. I don't want to rely or trust it. Not that I distrust it. I just don't want to use it. If you say, give me a disclaimer of warranty clause or something, it goes out and searches its information that it was trained on, maybe an okay place to start, but not an okay place to end. If you work your way through this in thinking about contracts. And I've had people for fun say, Steve, I've got a UCC question. And just for fun, I asked one of the AI software what the answer was. And they sent it to me for fun. And the answer was, 60% right. Oh, like that. Yeah. So, I certainly don't think it's someplace you want to end up. If you want something to mark up, but still do your own thinking, sure.
Yeah, I think that's the point. It's as they say, AI is not your pilot; it's your co-pilot. Yeah. I did play around one time putting down the terms of a promissory note and asking AI to draft the note. What came back was pretty good, actually. It was pretty good, but you shouldn't accept what AI gives you uncritically. You've got to go back and look it over and make sure it's what you wanted.
Well, thank you both so much for your time and your additional insights and answering all of our audience questions. And thank you all so much for submitting your questions. We want to thank you for joining us for another Justia webinar. Before you go, don't forget about Justia Connect Pro. That upgrade does give you access to CLE credit opportunities just like this one through live and on-demand webinars so you can stay informed and compliant. You will also get access to other benefits like our enhanced directory profile, the AI-powered Justia chat to help you get more leads, and exclusive discounts on Justia marketing solutions. If you'd like to learn more, you can go to pro.justia.com. Thank you all so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.